Hi everyone, welcome to our webinar. My name is Alina Kulikovska. I'm Business Development Manager in Eltoma Corporate Services, and today we will talk about company formation, maintenance and liquidation in Cyprus. Thank you for your attending us today. Please find on your left side of your screen the chat box where you can write all your comments, inquiries, suggestions, whatever. And my colleagues and I will contact you for the further cooperation and further discussion of your questions, if you have any questions or maybe your comments, whatever. Anything. So please don't hesitate to contact us. And I think that we need to start. Let's start basically from the law, because anything what we are talking about, company formation, maintenance, and whatever in any jurisdictions should start it with the law. So in Cyprus, we have the Companies Act, Companies Law of Cyprus, which is based on English common law and started from 1949, is common and used in Cyprus. The Companies Law of Cyprus regulates all aspects of a Cypriot company from the date of its incorporation up to liquidation. The law states that a shareholder bears responsibility according to the company's debt obligations, either identifiably or within the paid authorized capital. Who is this Register of Companies? What's its duties? We know that Register of Companies in Cyprus or in any other jurisdiction is the body who helps and keeps a register of all companies in Cyprus, recording and updating any changes of corporate structure. Information of Cypriot companies is provided by the register for a fee. Supervises the registration process of all Cypriot companies, correcting application forms and other legal documents. Register of Companies have their own website, which is current, and you can check any information about any companies. Which information you will find in Register of Companies in Cyprus? You will find information about name of the company, registered office, secretary, director, and status of the company. So it means it's active, dormant company, and did levy was paid or not paid? Did company provide and submit annual return, HE32? Anything. This information only provided in the registrar on their website. Any other information like certificates or some information about submission of some documents, service providers and clients can obtain only by a fee, for a fee, and only in paper, in hard copies. So that means that if you want to find information about the beneficial owner of the company or about the shareholders of the company in Cyprus, you will not find this information in open sources, in open registers. All these registers are closed, and basically, we do not provide a register with information about the beneficial owner of the company. So this information is also closed, but it's opened for service providers and secretary. So we, Eltoma, we'll talk about it later, basically, but we, Eltoma, as corporate service provider, as secretary of the companies, to whom we are providing services in Cyprus, we have access to all the information, all the documents about client. We have access and should have all the information about our client, about the beneficial owner of the company, about shareholder of the company, about director of the company, about everyone in this company. But we'll talk about this later. It's AML regulation, it's our QIC processes. And we will talk about this. We'll discuss which information should be provided for us as a service providers. and what we need to know about our client. Going further, so basically in Cyprus we have two types of companies. It's a public limited companies and private limited companies. So if we are talking about public limited liability companies, those companies should have more than 50 shareholders. They should have unlimited ability to transfer stock. They should have the right to offer company shares publicly. So that means that they can go to and for IPO. Yes. What about private limited liability companies? Those companies have less than 50 shareholders. The transfer of stocks can be limited as per the Articles of Association or Articles of Incorporation to protect shareholders' rights. And here we have the preliminary rights of shareholders, where it's mentioned that if one of the shareholders wants to sell its shares to his or her shares to third party. In this case, first of all, we need to get the consent or waiver from all other shareholders in the company to get their consent to sell these shares of this person to the third party. Preliminary rights. What are the basic elements of a company in Cyprus? First of all, it's memorandum and articles of association or incorporation. First, shareholders, first founders of the company. It's board of directors, authorized capital investment, disclosure of secretary, and registered business address or office of the company. And let's talk about each element of the company more widely. So let's start from the memorandum. What is this memorandum? Contains the following information of the company, like company name, description of the present and possible future corporate operations of the company, responsibilities of shareholders, limited or not, the authorized capital allowed to release and paid upfront at the time of incorporation, names and signatures of the founding shareholders and their contribution of authorized capital or investment. Articles of Association or Incorporation define the rules of procedure and protocols of the internal operations of the company, which include capital use of funds, class of shares, defines shareholder rights for selling of shares and stock succession in event of death of shareholder, define the shareholders' pro rata rights to purchase more shares, protocols to increase or reduce authorized capital, rules for conducting shareholder meetings, voting procedure for when shareholders meeting is conducted, procedures of communication to the board of directors with shareholders. The articles of association should also include rights and duties of directors, appointment, resignation, and dismissal of directors, procedure for the distribution of dividends, duties of company secretary, protocols for appointing auditors and conducting audits, procedure for the liquidation of the company, and any additional rules, protocols, and procedures agreed upon their founders for govern the corporation. Next is the founding shareholders of the company. This person must sign the articles of association and memorandum. It can be one or more persons. They agreed to pay a contribution to the authorized capital. Shareholder signatures must be notarized by a qualified lawyer in Cyprus. The signatures remain in the registers of the companies with the articles of associations. What are the powers and shareholders' rights? Shareholder rights are limited to their contributions to the authorized capital and includes participation in the shareholders' meeting. Shareholders have no rights to company property, they only have the right to dividends paid in accordance with the Articles of Association. Shareholders have no management duty. Their participation is solely through the meeting of shareholders. Shareholders have no liability to company debt and are limited in loss equal to their contribution to the amount of authorized capital. We will talk later about authorized capital and which types of share capital we have in Cyprus. But this is the main powers and shareholders' rights. Here they are mentioned briefly. So next is the director or board of directors. Basically in Cyprus we can have one director. There are no restrictions for the residency of this person. It can be legal or individual, legal entity or individual, and it can be one person or number of persons. They both can be legal or individuals. And in this case, they will have a board of directors. But who are those directors? Directors are appointed by the founding shareholders of the company. The minimum number of directors is 1. Directors can be corporate or natural persons, as I mentioned already. Local resident directors are not obligatory in Cyprus. Duties include electing the recording secretary, establishing the registered address, and preparing the company for trading. Directors have a fiduciary responsibility for the official reporting to state bodies. A director is not typically an employee of the company and therefore is not paid unless they has a signed employment contract. So basically in this case, if you are using some nominee director, I'm sorry, but we couldn't use this nominee, but some other person as a director of the company whose information is matched in the register of the companies. In this case, this person not obliged to you are not obliged to pay this person, and this person not can't demand from you any payment or any other monthly payment as a salary, remunerations, unless you sign employment contract with this person. In any other cases, you shouldn't pay monthly on a monthly basis. A director may receive an annual bonus decided and approved at the annual meeting of shareholders. So these AGM reports, AGM documents, which we are preparing on yearly basis, there we mention, do we have to pay any bonuses to the director of the company or not? What about powers and duties of the director? So directors have criminal liability for deliberate misrepresentations of accounting and tax reporting. Directors have a fiduciary duty to observe all requirements of the tax law and host nation regulations as required by the governing bodies, or the main duties and responsibilities. What about authorized capital? The minimum authorized capital is €1. Divided by authorized shares, the minimum face value of a share is €0.01. Authorized capital may be referred to as authorized issued or paid up capital. So we have 3 types of capital: authorized, issued, and paid up. What about authorized? Authorized share capital is those capital mentioned in the Articles of Association and shows the maximum amount of shares which could be authorized by the company. Issued capital, it can be any amount less than authorized share capital, which shows the amount of already issued shares which belongs to the shareholders of the company. And paid up capital means those amount which is paid for the issued shares. So shareholders can have their paid up, can have their shares which can be less than authorized capital, and they can pay the amount less than issued capital. So paid up capital can't be more than authorized, and authorized capital can't be more than the issued capital can't be more than authorized capital. There is a term called additional authorized capital share premium. Authorized capital should be paid within 12 months from the date of incorporation of the company. Authorized capital, it should be noted that in Cyprus, in the case of an issuance of supplemental shares or an increase in authorized capital, a stamp duty of 0.6% should be paid. In some cases, under specific conditions, a term called additional capital is used to avoid payment of this duty. Who is the company secretary? Company secretary can be a non-resident of Cyprus. It can be as natural and legal per entity. Prepares and files documents in Greek to the state register. The secretary's duties include taking note of all director and shareholder meetings, storage of records and corporate documents at the legal address. The secretary has a duty to submit the annual report to the Register of Companies. Office or registered address. This is the official address is registered with the Register of Companies. This is where all the official tax and corporate documents are sent at the request of the company secretary. The company's official documents are accessible upon request for free or for a small fee, dependent upon the request and company policy. The official address must be registered in Cyprus. The operations of the company do not have to be located in Cyprus. But basically now we face the situation when banks in Cyprus, they demand from companies incorporated in Cyprus to show that they have operational address and real business in Cyprus. This means to prevent those understanding of shell companies. When companies are providing offshore services, they are not representing in Cyprus. In these cases, all banks in Cyprus, they ask clients to provide proof of business address, proof of real address in Cyprus, proof that company has employment contracts signed with some employees who are working on this address. So be ready that today or tomorrow your clients, they will come to you and ask you to help them with providing business address to this Cyprus banks, and be sure that Eltoma Corporate Services can help you with this. We have some solutions how to help our clients and which documents and information should be provided for them proof of business address of the company. So please contact us and we will discuss with you how we can help to you and your clients. Know your client, QYC rule. This procedure is intended to record information of the beneficiaries, shareholders, directors, and sources of the income of the business. So that means that QYC process is a process to know your client. It's a process when we are asking our clients to provide information about all legal and physical persons in the company structure. We're asking to provide, for physical persons, we're asking to provide documents which prove their ID, residential address, signed CV, bank reference letters, etc. Those documents are basic, and Eltoma Corporate Service, as a licensed service provider in Cyprus, we have to check all our clients. because we are reporting before CISIC in Cyprus, and in this case we need to be sure that all the information about our clients, this information not prevent the principles of doing business in Cyprus, and also any of our clients, they are involved in money laundering or terrorist financing, whatever. Identity authentication is used in accordance with an international passport. The passport is checked using World Check or with a World Compliance System. And our Department of Compliance is helping with this, assisting us to get information about our clients. Confirmation of place of residence is required using a utility bill, such as a phone bill may be used. Phone bill may be used like when it's cell phone. If we are talking about mobile phone, unfortunately, we couldn't use it as a proof of residential address. What we can assist? We can assist if you don't have any utility bills, you're living with your wife or husband, you cannot prove that you have a residential address, exact residential address. In this case, we can ask you and advise you to provide, for instance, utility bill for not from electricity or water services, but from internet or whatever. Some clients may be classed as high-risk clients, such as clients that registers without being physically present, so-called also politically exposed persons. And with high-risk clients, the service provider is required to perform annual updates. Those clients who have low risk do not need this requirement, and we are checking them once per 3 years. But in a case when you or your client has changes in his residential address, passport, or any other documents, initial documents, you have to provide this information and update us with this. Because we need to proceed with a new check, we need to save all the documents, and Eltoma, the service provider, should have all updated documents about their clients. So please, don't hesitate and don't afraid. Please contact us, send us all the information. If you're a service provider, please tell your clients to provide us with this information. Nominee services. This is some services we are providing for Cyprus companies in Cyprus, and nominee service help provides privacy and protection of the personal details of shareholders and directors. There are two types of nominees, nominee shareholder and nominee director. The legal term nominee director doesn't exist. The director of the company remains the director identifiably and bears all responsibility and powers. The concept nominee shareholder is legalized through the concept of trust. It's impossible to completely remove all risks. The risk can be minimized with a correct corporate structure, presence of a second director shareholder, a detailed articles of association defining the company is prudent. For instance, introduction of restrictions on powers of directors, restrictions on the transfer of shares, sales of company property, careful selection of a service provider, and accurate prepared documents is recommended. By adding protected clause to the article of association, you can restrict the powers of the nominee director, for example, requiring a real director or shareholder to also agree or by requiring several nominee directors to agree to a measure change in the company. It's also recommended to allow a majority of directors to reverse unwanted actions of nominee directors. Signed agreements with the nominees and the actual company owner is in practice the following documents are required. As a trust deed where both parties confirm that the nominee shareholder holds rights on behalf of the owners. A contract with an open date for the sale of shares by which any independent service provider can make changes to the registrar according to the instructions of the beneficiary. Release of liability or indemnity letter in which it states that the director holds to no direct financial interest in the company and that the director acts in accordance with the instructions received from the beneficiary. The beneficiary exempt the director for liability from company management and responsibilities for decisions made even if they result in insolvency of the company. A resignation letter with an open date for the nominee director. Also, back to nominee service, it's very important to know that the indemnity letter only partially protect the beneficiary and the director as it's signed in contradiction to the legislation which allows the director to work against the interests of shareholders if it's in the best interest of the company. But Eltoma Corporate Services, we are providing nominee service in Cyprus, and all our nominees are signing documents which not against his or her will and which not prevent or involved in terrorism, money laundering. In this case, all the documents can be signed and no questions will be made by the nominee service. The only questions can be made by the compliance department because when we are receiving inquiry from our client for signing of documents by the nominee director or shareholder of the company, first of all, we are going to the compliance department, ask them to check if this information is correct and documents to be signed are correct. And then we are going to the legal department where they checked how is everything legal in this document. Are all the bases are legal. And after that, we can start with the process of signing of the documents. If you are thinking that all this is so long process, but I can assure you that everything is doing very smoothly and fast. So no information, no questions. If everything is correct, everything is legal, no questions will be asked by our compliance department or by our legal department. But let's go further for the company incorporation. And first of all, I would like to tell to everyone that for our partners, we have a good news. We have launched the process where all our partners who are who are interested in company formation with us in Cyprus, they will get the discount straight away. The discount in amount of 10% for our services, and for those clients who wants to work with us. Who are attending this webinar, they also can get this discount amount of 10% for the company formation and maintenance in Cyprus. So, company incorporation procedure contains with the choice of name of the company, signing of the memorandum and articles of association with notarized signature of the founding shareholders by a Cyprus lawyer, submitting the completed Cypriot companies forms to the registrar of the companies, obtaining the confirmation notification approving the incorporation and documents of the licensed company. Let's go then step by step. And for name check, approval the name. It can be a difficult process in Cyprus, as the name of the company must be unique. Other requirements can also make it much harder than other jurisdictions. A denied company name can be used by adding verbiage in front of the name. It must be added behind the name. Use of the owner's initials is offered used to make a denied name unique. If the application is denied, a new document can be resubmitted. Approval or denial can take up to 5 working days. The second step of the company formation is a preparation of memorandum and article association. One protocol unique to Cyprus is the requirement that original copies of the company's incorporation, memorandum, and articles of association can be both in Greek and English. The company's opening is dependent upon obtaining these originals. So those memorandum and articles of association should be prepared and signed in both languages, in Greek and English. In Greek, it should be as a must, and in English, it should be because most our clients, they are English speaking. So in this case, they will not understand anything in Greek. Both languages are acceptable by the Registrar of the Companies. So when we are incorporated, after signing of the memorandum and articles of association and preparation of sufficient forms for the company formation, we should submit documents to the Registrar of the Companies, and within 2 working weeks, we will receive the information that company was successfully incorporated, and we will receive the following documents. Please note that in a case you want to get all the certificates in English, you need to inform our managers, our staff members about this, legal representatives, and only after that you will get your certificates in hard copies in English. All the documents of the documents received by the Registrar of the Companies, like copies of memorandum and articles of association certified by the registrar. Please find that the originals remain with the registrar in the event of liquidation of the company. We will receive also certificate of incorporation, certificate of shareholders and capital paid by them, certificate of directors and secretary, certificate of the registered address. Those certificates are received by the secretary of the company. Documents in Greek, certificate of incorporation in Greek, and copy of the Greek memorandum and articles of association should be saved with the secretary of the company. Once we received the documents, we need to legalize them, and the good news that the Cyprus is a member of the GAA Convention 1961, and starting from this company, all the documents, company documents and QIC, the QIC documents, the legalization will be contained putting the stamp of apostille. The GAA Convention was signed by several states in 1961 and came into force in 1965, which resulted in simplification of the documents between the countries which signed the convention. Legalization through an apostille in Cyprus, as a rule, includes 3 stages. First is assurance of documents at the notary, the signature of the notary of the local municipality, assurance of the Ministry of Justice. Also, it's impossible to apostille copies of the certificates used by the tax authority or registrar, only originals or copies certified by the notary of court. In a case of apostillization of the passport, the original must be shown the Ministry of Justice or local municipality where the signature of the notary was confirmed. 3 days are required for an apostille documents. If documents go to the country which didn't sign the GA Convention, full legalization must be carried out through the Ministry of Foreign Affairs of Cyprus. And now it's time to talk about company maintenance and financials. Before starting this block of questions about maintenance of the company, I would like to announce that starting from the 1st of September 2018, we are announcing and we will start the new project for the transferring of companies from Cyprus, Singapore, and Hong Kong to Eltoma Corporate Services. We will provide in this case great discount and even in more than 35-40% discount for the transferring of the companies and further services which will be provided to the client for 1 year. So if you want, why it's better to work with Eltoma? It's better to work with Eltoma because we are located in those locations where we are representing our services, and this make us our services and fees for our services more compatible with our companies, service providers in Cyprus, Singapore, and Hong Kong. And for our Cyprus partners, for our Cyprus prospective clients, we would like to inform you that the amount for the company formation without providing any nominee services will cost less than 1,000 euros, which basically is cost more than 1,000. So look for us, waiting for our announcement, big one, starting from the 1st of September, and we would like to, we would be happy to see you as our client or partner. What about maintenance of companies? According to the company's law of Cyprus, storage of register, secretarial documents, etc. is required until the liquidation of the company. Accounting, maintenance, storage of accounting documents and reports are required for 7 years. Passing of annual audit and financial statements must be submitted within 12 months from the termination of the fiscal year. According to the company's law, the first annual meeting of shareholders must be within 18 months from date of registration until no later than 15 months in the second meeting. Representation of the annual report, HE32, must be within 42 days after the annual meeting. Payment of annual fee of 350, such name like company's levy, must be no later than the 30th of June of every year after 2011. According to tax law in Cyprus, the declaration of the estimated tax and its payment instructions must be submitted before the July 31st of the current year, and payment of the first fee, 50%, must be completed before December 31st. The second payment and correction of the first payment, 50%. Or for reporting purposes, payment of a final corporate tax before the 1st of August of the following year. Submission of the tax declaration IR4 together with the audited financial statements required no later than 12 months from the termination of the fiscal year. Delivery of the VAT reporting quarterly from the date of registration to report types VAT and VS. So you know that VAT is internal VAT system, VS is European VAT system. Payment of the other taxes dependent upon their type of defense on real estate and dividends to resident shareholders of Cyprus. In Cyprus, under the company's law, in cases of turnover less than 35 million euros, the 13 other conditions, the company can avoid passing mandatory audit. Audits are mandatory under tax law, so only the dormant company can avoid doing this, and the tax authorities can reserve the right to demand an audit if there is any doubt in the dormant status of the company. What are the main penalties for non-compliance of the Cyprus companies? For conducting the annual meeting of shareholders in an untimely manner, the penalties amount is 430 euros. For submission of the annual report in an untimely manner, the penalty will be in amount 100 euros, although this is not clearly stipulated. For a duty non-payment of 350 annual levy after June 30th for a 2 months delay, a penalty of 10% is owed, and for 5 months, the above 30%. How it's calculated? You have to calculate your 350 euros for SU annual levy, add plus 10% penalty for 2 months, and if you have pay penalty for more than 2 months, then you need to add 30%. So that means that you will have to pay amount 350, then penalty, and on this penalty for 30%. So the amount will be 490 euros. For failure to record registers of the secretary, for a failure to provide storage of accounting documents within 7 years, for untimely submission of changes on structure of the company, all violations started above have no accurately registered penalties, but registrar had the right to superimpose a penalty at its discretion. Companies changes. So we are talking about maintenance. All changes in structure of the company have to be registered with the registrar of the companies. On each type of change, there is a specific company format and set of requirements. Forms are filled out in Greek language. Changes can take less than 1 week, depending on the workload of the registrar's office. There is no set time for filing the registration of changes in the board of directors and the secretary, as well as the transfer of stocks, but it's recommended that it's filled with the registrar quickly to assure they are in force. Issue of new stocks shall be registered within 1 month, otherwise an extension of the registration period for shares issued from court will be required. And final step of our final questions is dissolution of a company in Cyprus. There are 2 different methods for dissolution of Cyprus companies. It's liquidation and strike-off. The main difference between the 2 methods, except the cost and timing, is that if a company or any member of a creditors of the company feels aggrieved by the company having been struck off the register, the court, on an application made before the expiration duration of 20 years from the publication in the Gazette of the notice for the strike-off if satisfied that the company was at the time of the striking off carrying on business or in operation, that the company be resorted to the register. In the case where a company has been dissolved with the members in voluntary liquidation, the court may at any time within 2 years of the date of dissolution, on an application being made for the purposes by the liquidator of the company or by any other person who appears to the court to be interested, make an order upon such terms as the court thinks fit, declaring the dissolution to have been avoided. So let's discuss the voluntary strike-off. It's a simple method, commonly used for international business companies that ceased activities and do not intend to carry on business in the future. Financial statements of the company must be prepared until the date of the company's ceased activities and filed with the relevant income tax return to the Cyprus tax office, and after the tax office examines and agrees these and any other tax liabilities settled, a tax clearance certificate will be issued. All the directors of the company must sign a declaration of solvency. This statement must be sworn before a notary public whatsoever it's no longer carrying on business and does not intend to carry on business in the future. Strike-off procedure normally takes approximately 9 months to be completed. For strike-off, it's in the case of companies not complying with the payment of the annual levy and any penalties which might occur, the Cyprus Registrar of Companies without notification can also strike off the company from its records in accordance with the provisions of the Russian tax law, Cyprus tax law. Please find that the company can be in a forced strike-off not only when when client denies to pay annual levy. In this case, Cyprus registrar also trying to contact the client and write the information notice in Gazette for the striking off of the company. And the procedures of forced strike-off and the voluntary strike-off are similar, but the main point that forced strike-off is when you have some penalties, when client doesn't want to renew with the company, or any other strong and serious questions arise. Liquidation. There are two main methods of liquidation: voluntary by shareholders' resolution and compulsory by court decision on announcement of creditors, and if the company is not able to pay off its debt's main reason. Members' voluntary liquidation, formal method, used only if there is a need for a liquidator to be formally appointed in order to distribute certain assets primarily for tax reasons. Liquidator must confirm that the company is sold. Statutory declaration needs to be made by the directors declaring that the company is able to pay its debts. All the debts of the company must be settled within 12 months from the commencement of the winding up of the company. Tax clearance certificate will also be obtained. Liquidator will call a general meeting of the shareholders, and the final court are then presented at the meeting. After the meeting, a copy of the final accounts and the reports of the final meeting will be sent to the register of companies by the liquidator for late than 1 week after the meeting. The certificate will issue the certificate of dissolution. These procedures take approximately 1 year for the liquidation of the company. If we are talking about compulsory liquidation, we're talking in this case we mean a court permission requesting the winding up of a company may be filed by the company itself, by any shareholder, by the official receiver, or by any creditor. A company may be compulsorily wound up by the court if the company is unable to pay its debts, etc. Unable to pay its debts means the company is indebted with a sum total exceeding 854 euros. The concerned creditor has served the company with a written notice demanding payment of the incurred debt due to the company failed to pay the sum due within 3 weeks from the date of the written notice was served. When a judgment was executed against the company's property but the execution failed to settle the debt, or when the court is satisfied that the company is unable to pay its credits, the court is of the opinion that it's just equitable that the company should be wound up. More about liquidation. Once the liquidation order is made, no action or proceedings can proceed with or commence against the company except by leave of the court and subject to such terms as the court may impose. Secured creditors might enforce their security. Once the liquidator has attributed the funds in his hands, summoned a final meeting of the company's creditors, he is realized how his duties. The company is dissolved from the date of the issue of the court order for the dissolution. For the conclusion of our today's webinar, I want to tell that some of many benefits provided to Cyprus companies, user-friendly and simple to understand, anonymity of shareholders, nominee trustee services available, English company documents, really available in English. So want to mention one more time that Eltoma Corporate Services is a licensed service provider in Cyprus, and we are waiting for you, for your clients, for your partnership inquiries. Please do not hesitate to contact us. My colleagues will contact you shortly, and please don't hesitate to ask them, to send them some questions, to send them some inquiries. If you are interested in partnership, we would like to contact you. If you are working in a bank and you can advise us some services to us and our clients, we also would like to work with you and cooperate with you. So contact us. We will sign agreement. We will. We have a lot of services to provide. First of all, we provide corporate services, banking services, accounting services, taxation, IT and web services, software development, legal services, migration services. We are obtaining license and permits. Also, we have our recruitment company, and we are hiring people for employees for us as Eltoma Corporate Services because we are dynamically independent and fast-moving company, and we also employ we also hiring for our clients. So if you need information about our recruitment services, please contact us. If you are looking for Cyprus real estate, please contact us, our website for property, and find the best solution for you. You can contact us on any of them, in any of our offices in Limassol, Singapore, St. Petersburg, Moscow, Kiev, or United Kingdom and Hong Kong via phone. Meet us in our offices or via email info@eltoma-global.com. Please don't hesitate to contact us, and thank you for your attention. Have a great day and week ahead. Bye.